Hustler Magazine versus Jerry Falwell. This case, if the Supreme Court had ruled in favor of Jerry Falwell, and I'll get into more details about this as to why, but it would have pretty much flipped Sullivan, the ruling of Sullivan versus New York Times, or the New York Times versus Sullivan, completely upside down. So the issue we have at hand and the main question that arose from this case was, does the First Amendment's freedom of speech protection extend to the making of patently offensive statements about public figures, resulting perhaps in their suffering emotional distress? So in other words, if you say something really mean about a celebrity and it hurts your feelings, is that speech protected? And the answer is yes. And into the facts of the case. First, we have Jerry Falwell, who is a nationally known minister, very popular amongst conservatives. He was very conservative. He was a very active commentator on both political and public issues. He was very, very outspoken about specifically gay marriage, gay rights, and homosexuals. He did not like any of that. Jerry Falwell, because he's a nationally known minister, he's a public figure. So, gotta prove actual malice if he wants to sue anyone. And on the other hand, we have Larry Flynt and Hustler Magazine. Larry Flynt, because he owns Hustler Magazine, in charge of it, is also a public figure. They decided to run a lead story, and it was a feature, and the feature was a parody on Campari liquor ads. And if you don't know Campari liquor, they ran ads depicting celebrities' first times trying their alcohol, but the ads were very sexual in nature, and while they were talking about their first time trying the drink, it sounded like they were talking about their first time having sex. And so when Hustler ran this parody ad, they did not make it sound like someone's first time trying a drink. They made it sound like it was Jerry. They made it very clear that Jerry Falwell was being indecent in these ads. Hustler and Larry Flynt basically went after Jerry Falwell on a very, very personal level. The parody depicted Jerry Falwell's first time as a drunken, incestuous encounter with his mother in an outhouse, and also depicted him as a hypocrite who preached only when he was drunk. Yeah. And there was small print at the bottom of the ad that informed the reader that this ad was a parody, not to be taken seriously. Jerry Falwell took it pretty seriously. His feelings were hurt, and he sued Hustler and Larry Flynt for invasion of privacy, libel, and intentional infliction of emotional distress. So right off the bat, he wouldn't get anything for libel because Hustler and Larry Flynt made it very clear that this was a parody ad, not to be taken seriously. So in other words, no sane person who knows how to read would take it seriously, because it was just a joke. This was taken to court at first the district level. Like I said, Jerry Falwell tried to sue for invasion of privacy, libel, and emotional distress, but he was only able to collect damages for emotional distress, which is pretty unsettling if you think about, because at that level, the court was basically saying, you had your feelings hurt, here's some money. And that's very, very, very dangerous, to be able to sue someone because you've had your feelings hurt. And I will get into that. Larry Flynt and Hustler appealed it, arguing the actual malice standard of New York Times versus Sullivan, and that must be met before Falwell can recover for emotional distress. And so because he was not able to collect anything for LaBelle, that meant there was no actual malice. Jerry Falwell should not be able to collect anything, and he shouldn't have been able to get any damages or collect for any damages because it was proven that there was no actual malice. Even if Larry Flynt and Hustler were going after Jerry Falwell on a personal level, and in my opinion they were, but they went after his pretty much his religious beliefs and his moral values, and so I can understand why that would hurt him on a personal level. Chief Justice William Rehnquist, during the decision-making, declared that the government interest in protecting public figures from emotional distress inflicted by speech that is patently offensive and intended to cause such harm cannot trump the First Amendment when the speech, as reasonably interpreted, contains no factual assertions regarding the figure involved, the public figure involved. In other words, a public figure cannot claim emotional distress without proving actual malice. Rehnquist notes political cartoonists and how they've contributed to political colloquy and reflection, and that they've enriched political discourse. And so he basically compared parody ads to political cartoons. And if political cartoons are protected by the First Amendment, then so are parodies. And so are your opinions, even if they are very negative and offensive and very harsh in nature. That's protected. A unanimous decision. The Supreme Court ruled in favor of Hustler magazine and of Larry Flynt, stating that because there was no false statements of facts with actual malice, Jerry Falwell cannot collect emotional damages. And to be able to collect damages for emotional distress because you've had your feelings hurt is not good. It would make it virtually impossible for you to criticize or disagree a public figure or a celebrity based on things that they've said. Falwell was very outspoken when it came to homosexuality and gay rights, and his opinions on that could be taken as personal attacks on a homosexual. And so if they weren't able to sue him to collect emotional damages, why would Jerry Falwell be able to collect emotional damages? And thinking about what that would have meant for the future is very is pretty unsettling. A celebrity or a public figure being able to sue someone because they've had their feelings hurt, you wouldn't be able to commentate on anything. In retrospect, you would only be able to agree with them. All aspects of criticism would be tossed out the window, and what gave us the ability to criticize these public figures and celebrities was the New York Times versus Sullivan case. And if the court had ruled in favor of Falwell, so the Sullivan case would have had no significance. And it would basically be like, yeah, we've ruled at this time that you need to prove actual malice, but if you have your feelings hurt, you don't need to prove actual malice, is essentially what this case would have meant. If they had ruled in favor of Jerry Falwell, journalism would look very different today, comedy would look very different, your opinions would not be protected. You virtually would not be allowed to have an opinion on certain things. If your opinion hurts a celebrity's feelings, they would be able to sue you. So the significance of this case, I thought it was funny at first that he was suing based on the fact that he had his feelings hurt. I thought it was very funny. I thought the ad was hilarious. But when you look at it more deeply, it's pretty unsettling. A lot of speech today would be suppressed if they had ruled in favor of Falwell. Satire virtually wouldn't exist. You can disagree with me if you want, but you should be allowed to say whatever you want. You should be allowed to have whatever opinion you want. It doesn't matter if it offends someone. In my opinion, offense is taken and not given. I think it's like the only time something is deemed offensive is if someone finds it offensive. So based on that logic, offense is taken and not given, and offensive speech is protected by the First Amendment. So if you don't like what someone says, tough. This decision basically is saying tough shit if you don't like what someone is saying. And if they had ruled in favor of Falwell, your opinions would not be protected. America would look very different if public figures were allowed to collect emotional damages regarding emotional distress without having to prove actual malice.